Good afternoon. My name is Mike Latcha. I am the current president of the AAUP chapter. And this afternoon we have another in our Know Your Rights series that is going on with grievance procedures. It is my distinct pleasure to introduce Jennifer Thor, who is an associate professor of management in the SBA. She also serves as the director of BIS here on campus. Jennifer earned her JD from the University of Detroit Mercy School of Law and her Bachelor of Arts from Michigan State University, James Madison College. She is also a licensed attorney and a former research attorney for the Michigan Court of Appeals and for the 19th District Court for the state of Michigan. She has served as a grievance officer since 2019 after spending some time working with Kevin Murphy, our former long-standing grievance officer. Jennifer has even taken on the onerous task of serving on the bargaining team, and she is, just in general, an amazing asset to our chapter here on campus. And she fields phone calls from Amy Pollard at least 3 or 4 times a week, sometimes 3 or 4 times a day. So with that, I will turn it over to Jennifer, and thank you.
Thanks for that, Mike. Hi, everyone. I hope I get to meet all of you in person. If I hope I don't get to meet you though through this grievance process. It is if I'm meeting you through the grievance process, it means that you're not being treated very well, and that's not something that I like to do, but I try to help where I can. And I hope that this presentation gives you some good information going forward if you do ever experience a situation where you think maybe the contract is being violated and it's negatively impacting you. All right, so first, before we get into everything, we probably need to understand what is a grievance. And our contract actually defines it pretty broadly and not too specifically, at least in paragraph 188, where we find this definition, which is any claim arising from the application or interpretation of this agreement. So if you believe that Oakland is applying the contract incorrectly or interpreting the contract incorrectly, then that is possibly a grievance. And when I say Oakland, the person or the individual, the entity that we grieve in this process is Oakland University administration. And typically that's people at the dean level or above, or the dean's office or above. We will often get, calls about actions of chairs, and that maybe a chair is violating the contract. And chairs are members of our bargaining unit, and they are not considered part of the administration. And so a chair can't violate the contract, or at least in a way that we could file a grievance. Although the contract defines a grievance pretty broadly, there are some specific provisions in our contract that say, hey, if this is a negative decision for you, you can file a grievance about this particular incident. So for example, in paragraph 41C4, which is our tenure promotion, part of the contract regarding tenure and promotion, if you get a negative decision regarding your tenure, that is grievable. There's a discipline provision. So if Oakland believes that you have participated in some misconduct, there are provisions that OU can take under our contract, paragraphs 65 and 66, that they can discipline you. And if they violate the procedures in this provision, we can file a grievance. Paragraph 67 allows Oakland to request a medical evaluation of faculty if they believe that your performance in the classroom is suffering due to a medical condition. If they take disciplinary actions as a result of this, we can file a grievance. And then there's a paragraph, paragraph 72. So if you are engaged in work outside of OU that pays you for that work, if Oakland thinks that that outside work is interfering with your primary duties here at Oakland University, they can request that you stop doing that outside work. And that is grievable if they were to do that. So these are specific provisions in the contract where it says you actually have a right to file a grievance if these provisions are violated. The contract is very specific as well as to certain matters that we cannot file a grievance over. So even if we think that the contract's being misapplied, if it falls under one of these paragraphs, we can't file a grievance over it. So for example, paragraph 13, if OU refuses to give someone emeritus status, we can't grieve that. If an action of the CAP or an action of FRPC it is contrary to your favorability, we can't grieve actions of the CAP or the FRPC. And this goes back to the thinking that we grieve actions of Oakland, and members of the CAP and members of FRPC are members of our bargaining unit, and so we don't grieve them. If you're denied promotion if you go up for early tenure or early job security, that's not grievable if you get denied at the early stage. And the reason for this is because you don't lose your job when this happens if you're going up early, and you still are able to follow the regular process of promotion under the regular time frame. Similarly, for full professors, if you are denied promotion for full professor, that's not grievable. The full professor review is not a mandatory review, and there's opportunities for you to go up again as well. And I'll talk a little bit later about other avenues if you get a negative review or determination if you were going up for promotion or just another review. Another paragraph that is very specific in our contract about not being able to grieve Oakland is the information they provide in our contract about various insurance that they offer us as a result of the contract. We can't grieve them over that information because it's obtained from a third party. There's paragraph 160, which allows Oakland to hire replacement faculty if a faculty member has gone off on a partially paid leave. However, if OU fails to hire a replacement instructor, we can't grieve that. And then for those faculty members who are research faculty or full-time practitioner faculty, the decision to reappoint them after their contract has expired, we can't grieve that as well. So if you think that the contract's being misapplied or misinterpreted and it doesn't fall under one of these paragraphs, then it's possible that you have a grievance. And so we need to figure out what to do at that point. So if you do think that you have a grievance, I recommend and we recommend that you immediately reach out to the union. It's important that the union is notified about these incidences, these potential violations of our contract. The first person you need to reach out to is Amy Pollard, our executive director. Amy's in the office more often probably than I am in my office. And so reaching out to her, you're more likely to get a response quickly from her. We are fortunate that Amy has been able, in her years of service here at OU, she's been able to develop some really good relationships across campus. And so sometimes you may have an issue, you reach out to Amy and she's able to make a phone call and resolve it relatively quickly. If the situation is more complicated or something that a phone call is not going to be able to address relatively quickly, then Amy will reach out to me. Possibly the grieved faculty member will reach out to me, and we'll investigate whether or not we should be filing a grievance. And it's important that you reach out immediately if you think that you have a grievance, because there's timeframes in our contract that require or that we have to follow. And so a grievance under our contract needs to be filed within 30 days after that grievance arises. And the way we count those 30 days, those are business days. So we don't count Saturdays and Sundays, and we don't count any days that Oakland is not open. So, for example, we had those cold days recently. We wouldn't count those as well. So 30 days is not a lot of time to to prepare for and file a grievance. So again, the sooner that you realize that maybe there is a contract violation, the sooner you reach out to us, the better. Um, when we file a grievance, that grievance needs to have some specific information in it. So the first thing it needs to have are all the facts surrounding that grievance. When we file a grievance, we're putting the university on notice that something is wrong, and we want them to take corrective action. And so we need to be very specific and detailed when we file a grievance. So we need to make sure we know all the facts. We have to tell the university which parts of the contract we believe are being violated. So the grievance is going to be very specific as to those provisions. And then when we file the grievance, we have to request any relief that we want the university to provide to the union. Now, most of the time when we file a grievance, the university is not surprised. They will have heard from Amy, they may have heard from myself. Usually they have heard from the faculty member who believes that they are not being treated properly. Um, so this should not be a surprise for the university that the union's taking this action. However, there are times, especially given the 30-day time frame, if we're not notified about a grievance and it's and that 30-day time frame is coming too quickly to a close, we will, to protect our faculty members' rights and the union's rights, we will file a grievance. And sometimes it takes the university by surprise because we haven't reached out to them. But most of the time we've reached out to them beforehand and we try to resolve it before we have to file a grievance. Now, who can file a grievance? It's There's multiple people allowed under the contract who can file a grievance. The faculty member, so the faculty member themselves can file it. A group of faculty can file a grievance, and then the union can file a grievance, and that's typically what happens. The grievance officer files any grievances on behalf of the union. Now, if a faculty member decides to do it on their own, the union is kept informed about that. So, and the union would be part of that grievance as well. We would be included in it, even though we didn't file it. So, if after you've talked to me, you've talked to Amy, and the union decides not to file a grievance, you can still do so. But usually, we've decided not to file a grievance because we think there is no violation of the contract. Now, once a grievance is filed, and the filing of it, when I first started doing this, I thought it was some, you know, some special place I would have to go at the Wilson Hall to file these grievances. It's basically we file them with HR. as of now, we file them by email. Email is a great way to have that time stamp on it that of when we filed, because you've got the proof in your email that that's what was sent to them on a specific day. So those 30-day timelines are kept pretty tight. Before email, we actually would walk down to HR and have them time stamp that they received the document, but we don't do that anymore. So once we file the grievance, OU and the grievance officer have 10 days to set up what we call a step one meeting. And that meeting needs to take place within those 10 days. At this step one meeting, we meet with the contract says a person designated by Oakland to conduct these meetings. That person that OU has designated right now is Eric Herpich. He is the Associate Vice President of HR. And we hold those meetings. Right now, we typically hold them over Zoom. Before we held them in person, but Zoom is more convenient for all of us. And it's at the step one meeting that we do a little bit of fact finding. Usually, OU comes to these step one meetings not having done much investigation on their end. They want to hear from the union, what exactly is going on. And they're trying to figure out who on campus they need to be meeting with and dealing with to try and figure out how to possibly resolve this grievance. It's also a time for the union to figure out, what the administration knows on their side of what if they have done some investigation, then they will tell us what they know. And so usually at step one, we don't resolve the grievance because it is this time for us to figure out what each side knows. After this meeting is held, OU has 10 days in which to submit to the union a written response or a written answer. Um, I think every single grievance I have filed since I've been grievance officer, their answer to step one is always to deny the grievance. Um, And so knowing that, I know that's what's going to happen. They deny everything, but then they always say that they're willing to continue to keep discussing so that we can resolve this grievance, which is great because that's what we want. We want to be able to keep talking and resolve the grievance, but it can be frustrating when we know it's a clear violation that they just won't admit it. So after they have submitted their answer, and it is going to be a denial, the union has to determine whether that answer is satisfactory or not. If it's unsatisfactory, the union has 10 days to request what we call a step two meeting. And once we request that step two meeting needs to take place within the next 10 days. So typically after I get their answer from step one, I immediately tell them that it was unsatisfactory and I demand a step two meeting. The step two meeting is supposed to take place with a person from the provost office. It's Right now, my step two meetings typically take place with the Associate Provost for Faculty Affairs, which is Nivedita Mukherjee. Um, and Eric Herpich is in those meetings as well. The thinking is that as we move up into the hierarchy of OU administration, that a person at that level will have some kind of settlement authority and may be able to finally resolve this dispute. That's not always the case that they have this settlement authority. But that's the theory of why we have this stepped response here. Um, Now, during this step two meeting, it is possible for us to schedule multiple step two meetings. Basically, we're extending the meeting over multiple days, sometimes weeks. It's often helpful, depending on the issue, that we may need to have, the dean of a particular school actually come to the meeting. And so that may take a while depending on their schedule, to get them into these meetings. And so the step two process can take um, a little bit longer, even though we have these 10-day mandates under the contract. We're allowed to extend both step one and step two, if we believe that negotiations can continue and might lead to some kind of resolution. And for the most part, when we get to step two, we do resolve these grievances. We reach an agreement with OU. It's, oftentimes a compromise. We don't get everything we wanted. OU doesn't get everything that they want. But we've been able to resolve quite a few of our grievances at the step two process. And that's, really what we want. That's why we have this process in here, is to have us all, come to the table and, work out where we see some violations of the contract, so we don't have to take it much further. But there are situations where we just can't resolve it. And in those situations, after the step two meeting is done, OU has 10 days to give us another written answer. If we haven't been able to resolve it at step two, that written answer is always going to be a denial of the grievance again. And it's at this point where the union has to decide whether they want to take this further. And the next step is arbitration. Once we receive the university's response to step two, we have 30 days to decide whether or not to take this to arbitration. This decision to go to arbitration isn't my decision to make. This decision is actually made by the executive committee of the union. And under our bylaws, they are the ones who decide whether we take anything further into arbitration. Arbitration is a process that can be quite expensive. So, that's one of the reasons why we want the executive committee to decide this, so that they know exactly what kind of expenses this could be. We have to hire an attorney to represent us in these proceedings. And arbitration can take a long, long time. Under our contract, when we file a demand for arbitration, um, we have 10 days to get together with OU and pick an arbitrator. And an arbitrator is somebody who's supposed to be neutral, doesn't know OU administration, doesn't know the union, someone who can be unbiased in making these decisions. In my experience since being grievance officer, and the few arbitration that we've filed since then, we have not been able to get together with OU within 10 days and agree on an arbitrator. And when that happens, when we can't agree on an arbitrator, we then resort to the rules of the Federal Mediation and Conciliation Service. And they have a process where they have a list of arbitrators, and they send us the list. We take turns, OU and the union's attorneys take turns scratching off names of people that we don't like on this list. And at the end, whoever is left after we've scratched off all the names, that's who the arbitrator is. This process, should not take a long time, but unfortunately, it can. And that's because of who Oakland chooses to hire as their counsel to represent them in these proceedings. He tends to like to delay them quite a bit. Um, Once we have an arbitrator selected, though, then it's up to the arbitrator to decide, when and how this arbitration gets resolved. Typically, an arbitration is conducted similarly to a court proceeding. So there'll be a court reporter, there'll be witnesses, and at the end of the arbitration proceeding, the arbitrator will issue a written opinion. When we go to arbitration, the decision is taken out of our hands. We present the best case that we can on behalf of our faculty, and it's then up to the arbitrator to decide whether we should prevail or not. So there's a bit of risk in going to arbitration because you are never totally guaranteed of what the outcome would be. I just wanted to highlight some recent grievance successes, or since I've been the grievance officer. We've had some successes for re-reviews. I mentioned that the decision of whether to grant tenure or not is specifically mentioned as something that can be grieved. Um, there's a provision under 41C4 that allows, though, instead of filing the person who's denied tenure can ask for a re-review. And we've seen some, and when you go through the re-review process, you give up your right to a grievance. But we've had some success with these re-reviews. Sometimes a faculty, may submit their materials for tenure, and for whatever reason, when they've submitted those materials, maybe they're not presented in a way that's easily that the review committees can easily find what they need to grant that promotion. And so, I sit down with the faculty and we rework their personal statements, and we work with them to get everything in the right order. And we've had some great success with those. We had a grievance last year where uh, we were told that some faculty members in the School of Nursing weren't getting paid for summer classes they were teaching. Uh, we actually took this grievance all the way to arbitration. It was at arbitration, at the hearing itself, that OU finally said, okay, we'll talk settlement in this case. And after many hours trying to get the powers that be on the phone to agree to a settlement. We did reach one. Those faculty members received a back pay for one year of summer pay, and then going forward, they're getting their summer pay for that course. We've, ever since merit was put into our contract, we've had numerous merit grievances. We recently had one where a faculty member received a 0 score. Our contract is very specific about, when a faculty member can get a 0, and this faculty member clearly did not deserve a 0, so we had to file a grievance in that, and we're successful. We've had instances of deans not following our shared governance. Over the years, we've had a few newer deans who, for whatever reason, either weren't provided with our documents or chose not to review them, and it resulted in whole schools and colleges, running without any consultation with the faculty. And so we filed numerous grievances last year regarding shared governance, and got new commitments from the administration to adhere to shared governance, and it actually prompted the administration to create a handbook for their new deans and administrators so that they are aware of what they're supposed to do. Now, I can't guarantee that they're going to continue and always follow shared governance, but they know we're going to step in and we'll file a grievance when they're violating shared governance. We had a faculty member who was promised certain equipment upon hire. They never received it. We filed a grievance and received assurances that those items were going to be purchased. We've had multiple grievances over DSS over the years, most recently over the Glean recording accommodation for note taking. We reached an agreement with them about this. We're still working through that settlement. That settlement required the creation of a committee that would come up with a recording policy, and we're still working on that. And we're working with the new DSS director. That's what her title is. And uh, hopefully, we're going to see even better things from DSS in regards to faculty and student accommodations. We've also had to file some workplace or some grievances regarding workplace bullying in a particular school on campus. We had administrators not treating faculty members the way they should be treated. And we've had to step in and file some grievances there. We've actually had really great success in not filing grievances. And this goes to the fact that, Amy's been able to build some great relationships and make some phone calls and just uh, able to get things done, um, knowing that I think the administration knows that we will push them, we will file a grievance. And so oftentimes they will agree, trying to avoid having a grievance filed against them. So recently, we discovered that at the end of the fiscal year, there were leftover travel money for faculty, and that should never happen under our contract. There's never supposed to be a balance in that. The contract requires that, if a school has leftover money, then that money should be reallocated to everyone who had to shell out their own money when they traveled for research or a conference. And so when that was pointed out to the administration, they realized that was a mistake and they reallocated those funds. Um, uh, Last year, during the investigation of a grievance, we discovered some fiscal mismanagement that we actually had to report to our internal auditor, and so that was handled that way. Um, Varner Hall has had some building issues, and I know there's probably some members here who work in Varner Hall ever since the remodel. Um, for those of you who don't know, when they remodeled Varner Hall, they failed to address the soundproofing in the building. And, that's where our School of Music, Theater, and Dance is located. And, faculty who had offices right above some of the music faculty offices, or couple floors above music faculty offices, could hear, trumpet players, and it sounded like they were, right in their offices. So we did an investigation. Amy and I went to the building and walked around with faculty, and the associate dean saw us in there. And next thing we know, these issues start getting addressed. I don't know that it's completely fully addressed, but they are still working on it. We recently discovered, when we signed the new contract, we all got our signing bonuses for signing the new contract. However, we found out that certain certain members never got their signing bonus. Again, this was in conjunction with another grievance that a faculty member asked us, did they not get their bonus because of this grievance matter? And that should not have happened at all. Everybody was entitled to a bonus, depending on what your role was in the union. And then we discovered that an associate dean had access to some of their faculty's Moodle courses and was providing additional access to newer faculty so that they could learn how to teach certain courses. That should not be happening. You should know who's in your course and who has access to it. And so that was brought to the attention of the administration, and that was resolved relatively quickly without having to file a grievance. Um, that's all I have. Do you guys have any questions for me? I haven't been watching the chat. Hopefully somebody is.
There's nothing in the chat yet. Do you want to stop sharing and we'll open it up for questions?
Yeah, I'll stop sharing.
Perfect. I just want to re-emphasize two of the things you said. Number one is don't worry about if you think it's a grievance or not. If you're not even sure, reach out to me, and I know the contract. Jen knows the contract. We'll help you figure out whether it is one. So you don't have to feel confident about whether or not it's a grievance or what part of the contract it might refer to. We can always find that. And the second piece, I know Jen said it a bunch, but the timeline thing, almost every single time when Oakland responds to us, one of their objections to our grievance is almost always timeline related, even when it's not true at all. But it's a thing they throw at us all the time. So it is really, really important because it gets brought up a ton. So any questions?
Yeah, and going to the timeline, so they will object to the timeline, but they'll still talk to us and we can work through step one and step two. The timeline really is impactful if and when we decide to go to arbitration. It's there that an arbitrator could say, oh, you filed this too late, and then just refuse to even hear the complaint at all because it's been filed too late. And so, we don't want to have to go through all of that and then just to get turned down because they said it was too late.
If you have a question and you just don't want to ask it out loud, you can feel free to send me a message. Go ahead, Chabi.
Yeah, just curious. One of the last point you had on your slides, Jen, was unauthorized access to Moodle. Is it limited to administrators or faculty who happen to be chair or something like that, who has access?
Yeah, so the faculty of record should have access to the course. And
Meaning if chair accesses your Moodle pages or coursework, is that grievable or no?
it's gonna depend, and this is a comment I use frequently as an attorney. It's gonna depend, and it, more than likely, if it doesn't get corrected quickly, we'd probably file a grievance. Ken?
Do you find that the university has been infamous for just using the booking of meetings and multiple times changing the meeting date just before you're about to meet? Is that tactic gone away?
I wouldn't say it's gone away. I think it happens where they will delay. They usually will wait till the 10th day to say, oh, we need to schedule this, and can we extend the timeline? Oftentimes they may have a really good excuse, but they do tend to push the timelines. They like to push the timelines.
Okay.
Janelle said, back in the day, if real live classes, chairs and associate deans would pop into my classes randomly. Is that not allowed in an online world? Randomly? Gosh, I wouldn't think that was allowed anywhere, but Jen, how do you answer
Yeah.
that?
So, our contract enshrines the principles of academic freedom. And, so if you're feeling like, an administrator is, maybe trying to intimidate you in the classroom because, if they walked into your classroom, I would have issues with that. And in the online world, thanks, to Moodle, we do have control over who we can give access to. And, if your administrator is asking for access, you need to probably, know why, and you don't necessarily need to grant that access.
And we did recently, Oakland just recently updated the Moodle policy, and Sean worked with Nivedita and I to make sure that that covered all the bases properly, that administrators can't have access to your Moodle materials unless it's, part of it can be for accreditation, but they can't take materials of yours. They can't pass it on to another faculty member. So we got that pretty clearly enshrined in the Moodle policy. And so I think that that's really important. The other really important thing to know about Moodle is if you don't realize that you can produce all sorts of reports out of your Moodle, and you can find out who's downloaded, who's accessed. I haven't done a deep dive into it, but you basically can totally track what's going on with your Moodle. And that's what happened in one of these previous incidents, is that someone saw that someone who shouldn't have had access to their Moodle had access to their Moodle. So it is possible to check all of that and track all of that. Other questions, comments?
Will this PowerPoint presentation be available for
30
faculty?
way, 30 way.
Hold on, let me hit mute a second. The answer is yes. Yes, I have it recorded, and I will put it up on our YouTube page and then send everybody the link. I think with all of these Know Your Rights ones, we want to have these on our YouTube because they're the ones that people can go back to over and over again.
But
Megan?
maybe just the
sorry.
slides on the AUP page or something.
Usually what I do is I usually send out both, but that's a good idea, Chabi. I'll have Marta put it up on the website somewhere. I'll find a page. I like that idea. I will do that. Megan?
Yeah, since no one had any questions, we just had an incident happen where a faculty member was in the emergency room, and so she had students who needed to take a makeup exam. I guess our faculty absence policy is that the faculty member is responsible to get a substitute, but she was in the emergency room. So I guess administration is not supposed to get involved in the process, but is that typical? Like, I don't know. It seems like things can fall through the cracks, which it did. And there was kind of a issue. And anyway, I was kind of curious if what the faculty absence policy is in other areas, or what's typical. It seems like generally most places, like when you're sick, you call your boss and say, I'm sick, but I don't know what's typical, or if there is typical.
Yeah, I don't know that we have it typical. I mean, it's my understanding we really don't have a policy, and you kind of are, we rely on our colleagues to, step in, if needed. I don't know, Amy, have you had this?
I mean, I would argue it's absolutely the job of the chair. The chair's job is to make sure that courses are properly assigned. I would not at all imagine that should be the job of the individual faculty member. There's certainly nothing in the contract that would put that obligation on your lap. Whereas if you look at paragraph, I'm going to get it wrong. What's the chair paragraph? 80? No, that's not right.
No.
It's okay because we don't have chairs.
Oh, that's right. Okay.
Oh,
Yet another reason. Okay.
yes.
Right. So oh, again, then it would be Carrie, right? I mean, she plays the role in that sense in that school because she does the scheduling and whatnot. But I can't imagine a world in which that is an obligation of a faculty member. There's nothing in the contract that would put that on your lap. And
You might be getting an email.
I was just going to say, you can send me an email, Megan. Mike?
Yeah, there were no questions, and just in the spirit of asking an interesting question, you've been describing the grievance process from the point of view of the faculty filing grievances against Oakland. Is it possible, or has it ever happened that Oakland files a grievance against the faculty?
Um, Not that I'm aware of, and the way I read our grievance procedure, it defines who can file a grievance as a faculty member, a group of faculty, or the union. So I would argue that they can't, but don't give them any ideas, Mike.
No, no, absolutely not the point. It's just no. It's just it actually it's always been a question that I've had is that what happens if the faculty violates the contract? But no, that is not a question we need to answer
No,
because we don't.
exactly.
Chavi?
Yeah, I was another point on that PowerPoint was so individual faculty could file a grievance, and after, let's say, person goes to AUP and AUP is unwilling to or doesn't see merit in filing grievance, so faculty can file on his own, right?
Right, right.
And Jen also said that then AUP would be part of that, right?
Right,
Like
because
AUP will help, or is it just overseeing? Like, what's the role of AUP in that regard? And can they at any point jump in and say, okay, I think now we see that we should file or be part of your grievance here moving forward?
yeah, so the contract is between the union and Oakland. And if a faculty member decides to file without the union with them, we are notified because we're a party of the contract. And so we should know if Oakland is negotiating with a faculty member regarding the terms of our contract. And so we are notified, we're allowed to be in the room. We can decide, like, if after we sit through the step one meeting, we realize, oh yeah, this is really something we can join in on it. The thing is though, the faculty member can take it through step two, but they can't initiate arbitration. Arbitration can only be demanded by the association.
Colleen? We
Oops,
can't hear
okay.
you, Colleen. Why don't you go ahead and type it or see if you can.
No, no. Okay.
Oh, now I can
we
hear you.
now.
Yeah. No.
Yeah.
Yep.
Okay. All right. Great. I was just wondering if someone wanted to grieve a tenure decision, a denied tenure decision, would the clock for the 30 days start when the department voted no or when FRPC voted no?
It's actually when the Board of
Oh, now I can't
Trustees.
hear you.
Oh.
Hold on. How about now? Okay.
So we would be grieving the decision of Oakland, and that's when the Board of Trustees has their meetings and makes that decision. So the timeline would run from that.
Thank you.
Okay.
Carolyn?
Hi, I'm following what Mary's comments to you in the chat, but it's kind of
Oh.
going back to Megan's comments. So it's making me wonder. So if the university or the contract does not have a policy over anything, like just take away like the policies about covering classes, is do administrators have the authority to be able to have individual departmental faculty rules about something that this isn't in the contract, such as covering classes when the curriculum belongs to faculty? I guess that's what I'm questioning.
So the contract does allow for Oakland to create policies. And there's procedures of how Oakland creates policies. And the contract requires that they actually follow the policies that they create. So for this particular issue, I'd really want to see exactly what it is that they're claiming is the policy regarding this, because there's nothing in the contract, and I know in my particular department, I don't know for a fact that we have anything specifically regarding this.
We have a whole faculty handbook that is created mostly by administration. That
We're aware.
yeah. So things are added at various times to the point that it gets bigger and bigger. It never gets smaller, but it usually gets bigger and bigger, including like the role of the faculty of record is defined by administration and not faculty. So I'm overseeing our workload task force to be in compliance with the contract. And so this is one of the discussions we had, that when we're looking at workload, depending on what the School of Nursing is saying, what the faculty role is as an FOR, that's influencing our workload policy. So we feel that we have the right as faculty to define what the faculty of record workload, or what the faculty of record role is, and it's not just an administrative function. And so I'm just trying to clarify that.
So yours is a particular case, of course, as usual, but the issue becomes that if they want to create what they want faculty of record to be, then there's an amount of work that goes with that. And then that would be attached to the workload statement you create. So if a faculty of record has to do X, Y, and Z that equals this much work in your workload, you would be addressing that. In your workload, I would make sure that the new one that you come up with specifically addresses what a faculty of record does, so that it gets codified in a way that they can't just keep changing it. So in the School of Nursing, a lot of these issues are going to be on a case-by-case basis, and a constant, as you know, Carolyn, back and forth struggle, because part of it's lack of clarity, part of it's confusion because you do not have the chairs, because you do not have the structure that all the other units on campus have. So you all just have to keep fighting the good fight. Sorry, Megan and Mary and Carolyn.
Well, you know us well, so we'll just keep on at it.
We are getting close to 1. Is there any last questions, comments before we wrap up? No. Mike, did you want to close us out? Are you still here?
I am still
Oh,
here,
you are
yes.
still there. I'm going to leave it to you to
Yes.
close up then.
Well, thank you. And thank you, Jen, for this very informative talk. Thank you, everyone, for your attendance and your support. One quick note: if you have not yet submitted a university calendar survey, please do so by the end of the day tomorrow. The committee is absolutely in need of everyone's voice on this. It has ramifications that touch every single person on campus. So we need to hear from you. And with that, thank you, Amy, for setting this up, and have a good afternoon.
Bye, everyone.